Good morning, everyone, and welcome to day 4 of week 3 of this negotiated rulemaking session hosted by the Department of Education. My name is Brady Roberts. I'll be facilitating this morning, and I would like to move us quickly into a roll call so we can begin the subject of the day. So I'm going to ask folks to turn on their videos and just briefly say good morning as their name and constituency group is called out. So first off, we have Dr. Heather Perfetti, representing accrediting agencies.
Good morning, everyone.
Morning, and her alternate, Dr. Michael McComas.
Good morning.
Good morning. We have Ms. Jay O'Connell, representing FFEL lenders and/or guarantee agencies.
Morning.
Morning, and her alternate, Mr. Will Schaffner.
Good morning, everyone. 48 more hours.
Good morning. Next up, we have representing financial aid administrators at post-secondary institutions, Mr. Daniel Barkowitz.
Happy holidays and good morning.
Good morning. Happy holidays. And his alternate, Miss Alyssa Dobson.
Morning, everyone.
Good morning. Representing 4-year public institutions of higher education, we have Dr. Marjorie Doreen Williams.
Good morning, everyone. Glad to be back.
Good morning. And her alternate, Miss Rachel Feldman. Next up, we have representing independent students, Miss Michaela Martin.
Good morning. I'll be on camera shortly.
No worries. Good morning. And her alternate, Dr. Stanley Andrees.
Good morning, everyone. Pleasure to be here with you today.
Morning, Stan. Likewise. Representing groups, representing individuals with disabilities, we have Mr. John Whitelaw.
Good morning, everyone. I'll be subbing for Bethany. She will hopefully rejoin us this afternoon.
Thank you, John, and good morning. Representing legal assistance organizations that represent students and/or borrowers, we have Ms. Persis Yu.
Hello, everyone.
Hello, and her alternate, Mr. Joshua Revenger.
Good morning, everyone.
Good morning. Representing minority serving institutions, we have Ms. Noelia Gonzalez.
Good morning.
Good morning. Very early, 7 a.m. on the West Coast.
Very early and dark and rainy.
We're glad to have you and our other West Coast friends. Representing private nonprofit institutions of higher education, we have Ms. Misty Sabuna.
Good morning. Happy Thursday, everyone.
Happy Thursday. And her alternate, Dr. Terrence McTeer Jr.
Morning.
Good morning. Representing proprietary institutions, we have Ms. Jessica Berry.
Good morning, everyone.
Good morning. And her alternate, Dr. Carol Colvin.
Good morning.
Morning. Representing state attorneys general, we have Mr. Joseph Sanders.
Good morning, everyone. Glad to be here with you all.
Morning, Joe. And his alternate, Mr. Eric Afar.
Good morning, everyone.
Morning. Representing state higher education executive officers, state authorizing agencies, and/or state regulators of institutions of higher education and/or loan services. Winning the longest title for constituency group, we have Dr. David Canberg.
Yeah, thank you. Really pleasure to be here this morning.
Morning. And his alternate, Ms. Suzanne Martindale.
Hey, good morning.
Good morning. Representing student loan borrowers, we have Ms. Jerry O'Brien-Los.
Good morning, everybody.
Morning. And her alternate, Ms. Jennifer Cardenas.
Hola, buenos días. Good morning, everyone.
Representing 2-year public institutions of higher education, we have Dr. Bobby Ayala.
Good morning, ladies and gentlemen.
Good morning. And his alternate, Dr. Christina Tangalakis.
Good morning.
Good morning. Representing U.S. military service members, veterans, and/or groups representing them, we have Mr. Justin Hochschild.
Morning, folks. Pleasure to be here.
Pleasure to be with you. And his alternate, Miss Emily DeVito.
Morning, all.
Morning. Representing state departments of corrections, we have Miss Ann Presight.
Morning. Good to be here. Thank you.
Morning, Ann. And we also have the constituents group dependent students represented by Dixie Samaniego and Mr. Greg Norwood. They won't be joining us this morning, but we will announce them when they join the meeting. We are also joined by two advisors who I will announce, who have been providing expert feedback and guidance on subjects of PSLF and economic and/or education policy. We have Ms. Heather Jarvis.
Hello, good morning.
Morning, Heather. And Dr. Rajiv Darolia.
Hello.
Morning, Raj. Representing the Department of Education, we have Ms. Jennifer Hong.
Good morning, everyone.
Good morning. And our colleagues from OGC, we have Mr. Brian Siegel, among others.
Good morning.
Good morning. I also just want to say, because we are going to be picking up with PEP, we are also joined by Ms. Belinda Wheeler, who served on the subcommittee.
Good day, everyone. Good to be here.
Morning, Belinda. All right. Thank you, everyone, so much. And I see, yes, we have Carol joining the table on behalf of proprietary institutions. So good morning, Dr. Colvin. I would like to pick us up where we left off yesterday on the prison education program. And I'd like to first turn it over to OGC to speak on some of the questions that were raised around the Clery Act. And as we do that, I just want to remind our alternate negotiators, if you wouldn't mind just turning off your camera for the purposes of the live feed. So Brian, if you are ready, would you care to respond to some of the questions that were raised yesterday on that issue?
Sure, I can do that. I discussed this with Daniel after the session yesterday, just so I fully understood his question, and talked to our Clery Act compliance experts. The Clery Act compliance requirements are tied to campuses. So if an institution has a campus on within a prison facility and owns or controls a building or property in that, it would be covered by the Clery Act. We don't have a legal basis to exclude or to exclude those institutions from from complying with the Clery Act, or to provide an exception for them. We also don't think it would be consistent with the requirements of the Clery Act, which basically are to provide information to students or faculty who work at the institution. We are, however, open to providing technical assistance to the institutions which are in that situation and help them, structure their situation in such a way to mitigate the burden on them, or to find a way to comply with the requirements without imposing additional burden. From our understanding, this is a small number of institutions which are in this situation. Most institutions which are providing prison education programs don't own or control property. So we think it's much easier and a better way to handle it on a case-by-case basis, working between the Clery staff and the institutions, rather than to try to provide a broader exception, which we don't have authority to do. I also note that if it's a campus, it does have requirements under other laws, including Title IX, that we don't have any authority to address either. So, I don't, we understand the issue. We appreciate the concern of the institutions, but trying to build an exception here, one, is outside our authority, and two, doesn't work for us. So if there are any questions, happy to talk about it. And otherwise, I turn it back.
Thanks, Brian. Hold on back, because I do see a hand raised. So Alyssa, please go ahead.
I think that this is sort of a result of our concern of classifying these places as a location. and, agreeing that if it is operating in such a way that it fits the definition as is currently written for secondary location, then that makes sense. But when it doesn't, when it's offered, largely as distance ed, and you don't meet those other thresholds, Brian, that you talked about, such as owning or controlled by, then it shouldn't be classified as a secondary location to begin with. And then that does eliminate any spillover into these other issues and regulations that we're talking about, such as Clery. So I think that, the best way to sort of fix this and make it clear for everyone is not to classify them as a secondary location if they are not.
I think it's important to note that whether or not you define them as a secondary location, it's whether or not they meet the requirements under Clery as a campus, owning or controlling property. As you noted, that's a second requirement there. So, from our perspective, it's the second question rather than the first, which drives the Clery issue.
So if you read further into different pieces and parts of Clery, especially geography is one area that I can think of, it does refer to your secondary locations as Clery geography. And so it's just going to get even more confusing and appear as though you're not really complying with what is written.
Again, I think that's something we're happy to deal with on a case-by-case basis. We think there are ways to limit the burden on institutions. Again, we think it's, from our understanding, it's just a small amount, a few institutions which will actually own or control property. But it looks like to us, it would be helpful to have some discussions between those individual institutions and not address it in the department and not try to address it through a regulation which would likely have some unintended consequences.
Linda, I saw your hand. Is this related to the current topic of campus security report? Okay, you're good. Okay. Great. So with that, if there's no follow-up for OGC, I understand the department just has a very minor technical edit that they just want to walk through very briefly. So Aaron, if you wouldn't mind sharing the document now and just walking through that very briefly.
Yes, so under 668.237, because the department removed, let's see, well, we just had to do a technical edit to change. So on the draft that you all received, it says 668.241, and in parentheses it says 5 through 7, A5 through 7. But because we removed recidivism from the must assess to the may assess, the numbers kind of got out of sync. So we just updated the numbers. So it's so it'll be 668.241 A1 4 through 6 for reviewing and approving the method, for the creditor to review and approve the methodology. And I'll just take you down to 241 just so you can see exactly what we're talking about. So the creditor is going to be, we're proposing that the creditor review and approve the methodology behind the experience, credentials, rates of turnover for instructors, transferability of credit to at least one institution in the state or the state that most students are likely to return, and also whether the prison education programs offers relevant academic and career services. So that was just the one purely technical edit. And
much appreciated. So before we solicit and invite any final comments or questions on this, David, I see your hand. Anything else for OGC or as it relates to the technical edit? Okay, David, please.
Yeah, realizing that the 25%, no more than 25% is a statutory requirement, but previously it appeared, at least from what I've heard, that if a public nonprofit institution wanted to go above 25% or happen to be above 25% because of enrollment shifts, the waivers were granted nearly automatically, therefore relieving some of the administrative burden on the education providers. But it sounded like from yesterday's presentation that those waivers are being proposed to not be automatic anymore, and that there'll be a more robust process. I think I share a lot of Heather's concerns about the amount of administrative burden that we're putting on these institutions and their ability to even provide these services if we continue to overload them. So many of these institutions are low resource, understaffed. On the administrative side, preferring to focus their resources on the educational side. I wonder, I don't understand the 25% threshold to begin with. I think that's likely why it used to be an automatic process, because 25% was likely pretty arbitrary with no evidence, would be my guess. I would propose we continue the process as it's existed and not add any more administrative burden to these institutions around an arbitrary threshold. So that's my proposal. I welcome comments from the department or the subcommittee.
Yeah, Aaron, Stan, or Belinda, any response for David immediately?
Okay.
Belinda. Or well, Aaron and then Belinda. That's.
No, I'll let Belinda go. This was her. This was a subcommittee recommendation.
Yep. Thank you very much. Thank you for your comments, David. I definitely understand how the system has worked with the experiments for the first round and the second round. Looking holistically with the subcommittee experts that were obviously through different areas, but then also the work that Vera has done in supporting these sites during the experiment. The level of quality that we've seen has been all over the place with expansion, and some of it has been the highest quality that you could imagine. And as technical assistants that we have provided support, it's been really seamless. However, there's other situations where it seems that quantity has been emphasized more than quality, which is the reason why, speaking with my constituents, I brought it to the table for the subcommittee, this idea of scaffolding up to ensure that quality is maintained as an institution goes to that quantity part. So I definitely I hear you. I definitely hear your concerns. I just know from, a positionality of someone who used to be a prison education program director at a small, understaffed, underserved financially HBCU. I understand firsthand a lot of those challenges with administrative things and things of that nature. Also with the Vera hat, I also understand, just this positionality in this space. And that's why I brought it to the subcommittee that we really need to focus on making sure that, I definitely want education, and the subcommittee as well wants educational opportunities available to as many people as possible who are incarcerated. With a traditional student, if they don't like the quality of a program, they can literally withdraw from an institution and literally walk across the street to another campus and, start a different program. Our students who are currently incarcerated do not have that luxury. And I think it's really paramount on us to ensure that quality takes precedence instead of quantity. And then, of course, there are those scaffolds that allow that institution to go up to that 75%. So, I think we agree to respectfully disagree with each other. I appreciate you allowing me the opportunity to kind of put my insight as to why I brought that to the subcommittee and why the subcommittee did support very much.
David, any response for Belinda? Otherwise, I'll move on to Heather. Okay, great. Heather, please go ahead.
I would just add that I would share David's concerns about the process and the timeliness of that process as institutions are managing student populations and may see some increases to ensure that they received the waiver response in a timely manner.
Thank you. Yeah, Michaela.
A bit off topic than what's being discussed here, my apologies, but there's a section there in which says that in the decision-making process that key stakeholders have to be engaged. And I understand that like it's statutory, so they can't like be voting members, but I just really like on the record wanted to say that I hope that that is taken seriously and that folks really are engaged during this decision-making process and heard. And that isn't just kind of ends up being a tokenized position. It's like a checkbox from the regulations. I would look forward to hearing after how that ends up being incorporated as part of the process.
Okay, Stan, please.
Yes, so thank you, and pleasure again to be here with you all. I just want to make something maybe that's obvious, kind of clear, is you know, this has been passed into law that you know, these prison education programs, one way or the other in terms of how the regulations go, will move forward. So I mean, I think there's still, and I say that because you know, as an advocate in this field, I know there are just two sides to, or, you know, different sides to this issue, and you know, some people just don't believe prison education needs to be a thing. Period. Prison should be a place for punishment, and you know, I just want to emphasize that this is going into law. I mean, you know, we are debating on the regulations. I know that's probably clear to everyone, but you know, we want to here try to make it go in as effective as possible. And you know, so voting down does not take prison education away. It's going and moving forward. And you know, I would just reiterate that the subcommittee, which was made up of a group of diverse experts, is in support of the format that it's in. So, you know, voting down may not even do what you hope for it to do.
Thanks, Dan, and I appreciate the segue. And I think you're going to be the final comment on this, and then we will move to a consensus check on the language recommended by the subcommittee. No, Ann, please.
Thank you, Brady. And I just wanted to just take a second and say, as an operational person, I wanted to respond to Michaela's comment in that correctional leaders across this country take higher education very seriously in our institutions. It's a very important process that we engage in. And we believe as correctional leaders in being much more transparent than years past. And we rely on lots of additional stakeholders to help guide us through the processes. We're not education experts, so we need people who are impacted by our programs, as well as people who have that can guide us to be a part of that. We look at education like we do healthcare, like we do food services, like we do a lot of other things. It takes a lot of outside people to help give us information and resources. So for what it's worth, just know that the relevant stakeholders would never be considered token, if you will. We rely on those kind of people, and I appreciate the additional guidance from the department suggesting who are really credible people that we should consider consulting with. So thank you for that.
Thank you. Ann couldn't find my unmute button. So John, I see your hand, but I really would love to move us to a consensus check. Is it?
It's 10 seconds.
Go for it.
I just wanted to express our strong support for this, that folks in the disability community stand behind the work done by the subcommittee, and we are strongly in favor of this.
Thank you, John. And so with that, what I'm going to ask everyone to do is really clearly and in front of your screen, indicate a thumbs up indicating strong support, a sideways thumb indicating you can live with the subcommittee's recommended language, or a thumbs down, which means you have strong reservations against consensus. If that is the case, we'll provide you an opportunity to expand more on that. But with that, please, if everyone could show me their thumbs and I will announce them as they appear on my screen.
For the record, Dr. Stanley is taking the vote for independent students.
Understood. Thank you, Michaela. All right. Jerry, thumbs up. Anne, thumbs up. John, thumbs up. Joe, thumbs up. Jay, thumbs up. Persis, thumbs up. Heather, thumbs down. Bobby, thumbs up. Noelia, thumbs up. Carol, thumbs up. Stan, thumbs up. Justin, thumbs up. David, sideways thumb. Marjorie, thumbs up. Dr. McTeer, sideways thumb. Daniel, thumbs down. So we have 2 folks who are not in consensus right now. I would welcome if Daniel, if you'd like to come off of mute and share your serious reservations, then Heather, I'll ask the same.
So first of all, I want to express there's a lot to like in what's in front of us, and I am voting no with some concern that I don't want to express a no to the work of the subcommittee. I appreciate very much the work of the subcommittee, and I appreciate much of the work that's been done. The additional location piece and some of the concerns, and I know Heather will share on the accrediting side, are concerns for my constituency. So I can't get beyond them. That doesn't mean that I don't expect the department will issue regulations very close to what we have in front of us. I have significant concerns that you won't see the participation you want or any of us want because of those limitations. So that's the reason for my no vote.
Understood. Thank you, Daniel. And Heather, please.
Thank you. So I certainly also want to express appreciation for the quality of what the subcommittee brought forward. And I think from working with my constituency groups and also hearing from some institutions and having some additional conversation this morning with the department and trying to offer some alternatives, the department is seeming immovable on some areas that I think can easily help get those with reservations to consensus. And I think that those are also areas that the subcommittee expressed some concern in some of the regulatory language. So I do think that there are some areas that could be adjusted in a way that is beneficial for all constituents involved. I think the lack of clarity in process and institutional requirements, including the annual reporting, has raised concerns and has not been addressed. And then echoing Daniel's concern that institutions will exit this space if the regulatory burdens seem too great is also a major concern. So those are the primary areas for the rationale behind my thumbs down here.
Understood. Stan, I see your hand, but I just want to say, and this is always the intent with consensus checks, if there is proposed regulatory language that would move you to, at minimum, a sideways thumb, it's always recommended and encouraged you share that language with the committee with the intention that if there is time at the end of the week, we will return to issues where we are not in consensus to discuss that further. But with that, Stan, please.
All right, so that is what my question was going to be. So thank you, Heather and Daniel, for giving your reasonings. And I was just wondering, Heather, you mentioned that there was a conversation where you provided potential language remedies. Could that be shared with the committee?
It was around topics. There was some conversation about whether time should be spent on some suggested revisions, and they did not appear to be likely to be considered by the department.
Mr. Steve Finley, who, just as a reminder, is with the Department of Education in their OGC department. So please, Mr. Finley, go ahead. I believe you're muted right now. Apologies.
I think I put my hand down instead of unmuting, but I appreciate that reminder as well. It helps to understand I'm speaking for OGC. I think the department has addressed the concern about the Clery question. You know, as Brian noted earlier, it really is the definition of campus where that modification should be made to make it clear that as long as the site is not under the institution's ownership or control, it's not a campus and it's not subject to Clery. It does need to be an additional location for purposes of the department's tracking of these sites, given that there are separate requirements that attach to these locations. But it seems like if there's still residual concern for Clery, that perhaps that could be addressed in guidance.
Daniel, please.
So again, the example that I provided to Brian yesterday in caucus, and I'll state this publicly for the record, is a Florida college who I know was in the pilot program, who had a separate building at the prison at the carceral institution, at which they were providing instruction, and that building was under their control. It was not under their ownership. So I think the question is how, and again, it may be too much for the 2 days or day and a half we have left, but how we define control is a really important one. So it's not that they do not own the building, they do not own the space, but they are ceded the space and it is within their control. So, that is the real concern I have. And Steve, I appreciate the department's movement, and I would love to see that in guidance. And that is one of two issues. The more minor one is the second approval, but I could live with that. It's really the first that is my stumbling block.
Thank you, Daniel. Heather.
Just wanted to add to the comments earlier, and as a follow-up to Stan as well, I think that some of the areas that we were talking with the department about earlier today related to some shifts in the language that still held true to the statute, because we understand that much of this is governed by statute, but perhaps removing what is not governed by statute into a different category that was not a requirement, but was optional in terms of the assessment and evaluation relating to that best interest of the student section. There are certainly pieces of that are reflected in the statute, but there were some additions into that section that go beyond the statute, and those becoming a list of options for evaluation versus mandated requirements for evaluation seems a better approach.
Michaela.
Just because I know we're about to move on, I just wanted to give like a huge thank you to Dr. Andreas and Dr. McTeer, both of which are both on the regular committee and on the subcommittee, which means they're putting in like double hours and a lot of effort for all of this. And I think that you all did really great work. And to everybody on the subcommittee, but especially those folks that are on both committees, that's so much I can't even. So thank you.
Thank you, Michaela. And yes, thank you very much for the work of the subcommittee. Any final thoughts from the department on this issue?
Yeah, what I wanted to do, Brady, can I speak?
Of course, yes.
Okay, I wanted to share my screen again and ask, I wanted to share, you all can see that. Here is the proposed language that the department could offer to get to hopefully allay some of Daniel's concerns with campus security reporting. So I'll try to make my screen smaller. We'll find the appropriate place to put this in the regulations, but it would say a campus does not include a federal, state, or local penitentiary, prison, jail, reformatory, work farm, juvenile justice facility, or other similar correctional facility, no part of which is owned or controlled by an institution. So this is not the, I'm sorry, Brady, I just want to clarify, this is not the specific regulatory citation where the language would go. It's just, we can find the best place in the regulations for it to go to clarify.
Any feedback for the department on this new proposed regulatory text?
I appreciate it. I still think I'm stuck with the question of control. So, you know, and were I the only holdout, I may actually move to sideways here, but there are other issues. I know Heather has, we have concerns about reporting as well. They're for me, secondary concerns with their concerns, but I appreciate Aaron, this attempt. It still doesn't address, I need to know what happens if I'm in control of a space at a carceral facility and what that means. So, you know, campus, I do appreciate the carve out and I appreciate where the department is trying to go and I would support this language, but it doesn't move far enough for me to change the vote.
Any additional feedback for the department?
Oh, no, I have nothing further.
Anything for the department? Okay. Stan, please.
So I still am a little unclear on Heather's reservation in terms of, is it that we should more clearly note which was statutory and which was regulatory in terms of the best interest section? I mean, so I know we want to move forward from this, and I don't want to hold this up, but I'm just wondering is if there is language that you could provide to the committee to where we can maybe help workshop, you know, wordsmith it, and maybe move to a place of comfortability.
Thanks, Stan. So I offered the suggestion, and this is just one issue that I have, but I'm happy to explain it. On page, I think it's 10, there are assessment criteria that are listed. Some of those are by statute and some of those are not. I asked the department this morning if they would consider moving those that are not required by statute under the provision that speaks to recidivism, which is a may versus a shall. And there, I don't want to speak for them, but there did not appear to be the willingness to do that. So it's not a matter that I had to craft language. It was asking for those that are not mandated by statute to be more reflective of a laundry list of other criteria that the correctional facility and officials can consider, and also that institutions and other stakeholders can consider in assessing whether the program is operating in the best interest of students. And I believe that Terrence, who was with us this morning, also indicated that there were conversations at the subcommittee level around the possibility of other criteria that may be beneficial to consider, but those weren't included. So it's really a matter of all of the following have to be considered, moving some of those that aren't required by the statute in a more optional kind of reflected space in the regulation.
Aaron, your response?
So the regulation specifically states that all of the following must be assessed. And the reason the department came back to the table with the language in small b, which says the oversight entity makes the best determination through the feedback process with input from relevant stakeholders and in light of the totality of circumstances, was specifically to address that concern. We wanted to clarify that not meeting one of the requirements is not disqualifying, but it is an assessment of the totality of circumstances. The department believes that it is in the best interest of students to assess all of the indicators under the must column. Though that assessment will help the Bureau of Prisons, the institutions, the accreditors, all stakeholders involved in the holistic process determine whether these programs are in the best interest of students. Not meeting one indicator does not mean that the program cannot continue to participate. It is an assessment of the totality of this assessment of each of the indicators and a review of the totality of circumstances based on that assessment. So wanting to ensure that we're taking many, a holistic and the totality of the program into account. The department believes that all of those indicators are necessary to at least be assessed to get the best picture of the best, to ensure the programs are in the best interest of students. So I'll stop there.
Thank you, Aaron. So not seeing any more hands. Just to currently recap, we are not in consensus on the recommended language of the subcommittee right now. But of course, if there is time to return to this issue and who are holdouts would like to suggest preambulatory language or regulatory text that would move them to a minimum sideways thumb, meaning they can live with the recommended language, we would always encourage that. But with that,
Brady, I'm sorry, Brady, one more question. I just wanted to clarify, Heather, are you saying if we move, are you saying if the department were to move the completion indicator to the may assess, would that be sufficient?
No, I think I indicated that that's one issue of several others, and I'm certainly happy to send those forward. We had talked about them this morning, but I'm happy to send them in writing forward. And if we can circle back to this with some language with Stan and Belinda's input and other members of the committee, I'm hoping that we can do that and address some of this.
That's appreciated. So before we go to PSLF, I just want to give us a quick 10-minute break. Just so we can prepare for the PSLF discussion, and we'll return promptly, let's say at 10:55, so a 12-minute break. We will see everyone then. Welcome back, everyone. I hope you enjoyed your break. Thank you again to the committee and the subcommittee for all their work and discussion on these issues. And again, I do want to reiterate, the intention always is in issues we are not in consensus on. We will have time to re-examine things, so the department is always happy to entertain and look over new proposed text. And so with that, I want to move us pretty quickly on to issue papers 4 and 5 on PSLF. And Jennifer, it's my understanding you just want to walk through that a little bit.
Before we take the vote, again, thank you to the subcommittee on PEP. I know that they worked really hard to get us where we're at right now. And also, before we take this vote on PSLF, I did want to circle back to acknowledge Michaela's comment Tuesday afternoon during the public comment period regarding, the very compelling personal testimony we've been hearing about individuals' experiences struggling with student loan debt, or the aftermath of coping with what amounted to a worthless degree. I think all of us have been affected by this testimony, and it's disheartening to hear. And I know you were affected, Michaela, and I think it's important to acknowledge that. But it is Thursday of the third session in this unique process of negotiated rulemaking. Just want to bring us back here. I think the fact that we're here, we're having these conversations and making real and significant changes to improve these programs is a major undertaking and commitment on our part. Throughout the past few months, we've advanced the language before you based on the discussions from this table and the public testimony, and these changes have been substantial. In other words, we've not only made suggested changes throughout these discussions, but we've demonstrated our commitment every step of the way, including the prep work and outreach that went into this rulemaking. Even outside this rulemaking, the waivers we provided under the COVID emergency have already provided real relief to students and families. Most notably, the PSLF waiver, which, as we speak, is providing cancellations for public service employees across the nation. And specifically on PSLF, just to review again, we've poured through both written and oral public comments to make the changes that we've proposed. As a result, we've expanded the definition of full-time to be more encompassing and to ensure we include contracted employees and a broad definition for non-tenure track employment. We even inserted the conversion factor in contact hours for faculty as suggested by this committee. So thank you for that. We've clarified the definition of military service to ensure that organizations that serve our military and veterans qualify for PSLF. We've added several other definitions under the regulations to ensure we capture service provided by school-based services, public health professionals, public service for individuals with disabilities, and the elderly. We've clarified our definition of employer, providing a process of attestation on a form approved by the secretary. Notably, we've greatly expanded what can be considered a monthly payment, including flexibilities for multiple installments, conformance with our repayment plans, and including time and deferments and forbearances as monthly payments. You may recall one of our public commenters at our last session talked about her struggles with the overlap of her payment and transition from one employer to another. We responded. We clarified the language to provide that the individual qualified by employment at any point during the month for which that payment is credited. We've included language to ensure that payments on direct loans prior to consolidation count toward PSLF without the clock restarting. We provided for an automated process for data we may receive on federal employees and military service or any other entities in the future that we may receive on a data match. We've included a reconsideration process for borrowers that have been denied. Notably, we've also included hold harmless procedures for borrowers that have been steered into forbearances during their months of employment with a qualifying employer. We will include those periods of forbearance toward credit for forgiveness. And we've included language for FFEL lenders to provide more detailed reporting to the secretary on the program. So, I mean, these changes are not insignificant. We believe that these proposed changes could make real differences in the lives of public service employees seeking forgiveness under the program. We appreciate all the feedback to get us to where we are today, and we look forward to reaching consensus on this issue.
Thank you, Jennifer. And before I invite final comments on this subject, I just want to briefly go over how we're going to take the consensus check, it's going to go issue 4, which is improving PSLF application, the application process, and then issue 5, which is related to definitions. So we can walk through that one more time. But at this point, I'd welcome final comments on this. So Joe, please go ahead.
Hi, thanks Brady, and thanks Jennifer for the recap on the department's efforts here. At this point, I would like to call a caucus of all non-federal negotiators to go through issues 4 and 5. And in particular, I want to make sure that we have our experts in the room, and Heather specifically.
All right, let's pause the live stream and we can sort out the technology. Oh wait, Jennifer, before we do that, I don't know if it's already paused, but please.
I just want to bring to your attention that we have a very significant bar defense proposed language rule that we still haven't gotten to. We're a little behind, and if you're going to take if you want to take a caucus, please do. But if we could just be mindful of the time here, really appreciate it.
Okay, so with that, if you just want to pause the live stream, we can get everyone Welcome back, everyone, and I hope you enjoyed that break period while the committee was in caucus. And thank you to the committee for being expeditious in that caucus period. So I would now like to invite any final comments for the department and the committee's consideration before we move to a consensus check on issue papers 4 and 5 as they relate to public service loan forgiveness. Marjorie, please.
Yeah, thank you. I just have a really quick clarifying question with respect to the hold harmless procedures. There's a subsection that has a strikeout where it says excluding periods of in-school deferment. So are we to understand that to mean that if a borrower had deferment while in school, those deferments would count towards their 120 months or payments? Am I reading that correctly? Oh, sorry, and it's on page 9.
I don't know if
Do you want a second, Jennifer?
Yeah, can you go on to Daniel?
Oh, sure, we'll get back to that one. Yeah, Daniel, please.
And maybe I'm trying to answer Marjorie, so maybe Jennifer, this will help. What I read in that is that you can't qualify for months when you're in school based on that, because it's not, in-school deferment's not a deferment that counts under earlier in the section. So the restriction is if you choose to pay while for an in-school deferment, even if you're working full time, there's no way that could be counted. That's sort of what I understood it to be. The department may have a different read on it, but again, in-school deferment's not a deferment choice that counts as a payment period, but maybe I'm misinterpreting.
Okay, and so, sorry, go ahead, Jennifer.
I don't even know how that got in there, that strike through. I mean, I think that was probably just internally, we don't need to make that explicit.
Okay, yeah. And so then would those count for this, for what comes after, for making additional payments later on, or is it just, we're not talking about in school?
Yeah, we're not talking about in-school deferments.
Okay, thank you.
Mm-hmm.
Persis, please.
So my comments are about both 4 and 5 altogether. And I think, first of all, one of the things that's important to recognize, and we've raised this over and over again, is the link between income during payment and public service loan forgiveness. The reason why it's so important to get people captured into public service loan forgiveness is because income during payment has absolutely failed to get borrowers out of their debt. Right now, the best case scenario, you get cancellation twice as long. And it has, and frankly, close to no one has ever actually achieved that, right? And so it's so important, especially for our most low income public service workers, to be able to get folks into affordable payments that provide a reasonable pathway out of debt. And we haven't done that for income during payment, and we're not doing that for public service loan forgiveness. We know that low income workers are not looking at the tax status of their employer when they choose their job. So maintaining this distinction between for-profit and nonprofit is both contrary to the statute and harms the most low income workers. We know that low income folks, and all folks really, we've heard this over and over again, have been steered into forbearances, and that's what we're not counting. The problems that we have seen for the lowest income and most vulnerable borrowers have not been addressed in either income during payment or in public service loan forgiveness. And so that will be the basis for my vote.
Thank you, Persis. Not seeing any other hands. Jennifer, would you mind walking the committee what is actually subject to the issue number 4 consensus check? Oh, Brian, I see your hand. Go ahead.
Yeah, just want to remind committee members that once we have a consensus check or a consensus vote, If the committee reaches consensus, we are bound to publish the reg language approved by the committee on which we reached consensus as a proposed rule. That will be, there's a small exception for if we change language, we have to explain why, but we've never done that. We've never changed language that a committee has approved. And it's been very helpful when we've been asked by other offices or other parts of the government to change language to say, we can't because it was approved by the committee. So if we get consensus, we publish the language as approved. If we don't reach a consensus, we're not bound by anything that was included, that we included in the proposed language during these negotiations. So if there are changes that we made to accommodate concerns, they may or may not show up in the proposed rule. I don't know. I can't say they will. I can't say they won't. But there could be significant changes from what you see here in a proposed rule if there isn't consensus. So just wanted to make sure that you all know, and many of you are experienced negotiators, you've been through this before, but just wanted to make sure that was clear to everybody before the consensus votes are taken.
Thanks, Brian. Jennifer, if you want to queue up issue number 4 for us.
Great. Erin, did you want to queue up the language? Did you want me to project the language and just point to it? That'd be better. Yes. So issue number 4 is everything on page 4, starting from page 4, qualifying repayment plan till the end of the regulation deals with the application process. Yeah, right there. Starting from qualifying repayment plan to the end of the rule is issue number 4.
So they're transposed. 4 is on the bottom, 5 is on the top.
Yes, all the definitions are for issue 5 are at the beginning.
All right, thank you. If you wouldn't mind unsharing, Erin, just so I can see everyone's profiles very clearly. All right. So I'm now going to ask to see thumbs on a consensus check for issue paper number 4 on PSLF. I'll read them off. Waiting just to see a few more. Justin, you were first, which is why. Justin, sideways thumb. Marjorie, sideways thumb. Bobby, sideways thumb. Heather, sideways thumb. Daniel, sideways thumb. Joe, thumbs down. Jay, thumbs down. Noelia, thumbs up. Oh, sorry, Jay, sideways thumb, apologies. Yeah. John, thumbs down. David, sideways thumb. Jerry, sideways thumb. Carol, sideways thumb. Persis, thumbs down. Misty, sideways thumb. Michaela, thumbs down. Jennifer, thumbs up. At this stage, let's move directly into issue number 5, and then we can solicit additional guidance for the department. So Erin, if you want to reshare that document.
And issue number 5 is everything from the beginning to where issue 4 begins on page 4 to qualifying repayment plans. Just basically all the definitions, including eligibility, full-time employment. I see Raj has his hand up.
Oh, do you, Raj? I'm sorry. If you want to turn on your video, please. Or maybe it might have been an accident.
That was a mistake. That wasn't.
Okay. All right. Thank you, Erin. Now, again, to take an official consensus check on issue number 5 as it relates to PSLF, please, I would love to see your thumbs. Justin, sideways thumb. Marjorie, thumbs down. Bobby, I think that's a sideways thumb. Heather, sideways thumb. Daniel, thumbs down. Joe, sideways thumb. Jay, sideways thumb. Noelia, sideways thumb. John, thumbs down. Persis, thumbs down. Carol, sideways thumb. Jerry, sideways thumb. David, sideways thumb. Misty, sideways thumb. Michaela, thumbs down. Jennifer, thumbs up. So we are not in consensus on issues 4 and 5 for PSLF. Any new guidance or suggestions for the department before we move to IDR? Okay, Michaela.
I just wanted to reiterate that I just really didn't think that it went far enough that when we're going to try and capture public service, we cannot limit it to 501c3s and like any kind of corporate designation.
Thank you, Michaela. Joe.
Yeah, I'll be brief because I think the department knows where I am on this, but I don't think that we have done enough here to reduce the sky-high denial rates. I think we need to think bigger. It's about time in public service, and that has to be the focus in order to get people to qualify. I'm concerned that payment counting is going to continue to be an issue once the waiver is done, and I'm concerned that fail loans are going to continue to be a problem once the waiver is done. One idea that I haven't put forward that I'll mention here now is, although I know the department does not want to bind itself, if there could be some sort of acknowledgement of what the department is going to do with the data that they're collecting, I think that that would be a big step forward in terms of taking some kind of step to help fail borrowers once the waiver is done. Potentially, this could look something like if there's a data match and the department recognizes that someone both works in public service and has a fail loan, that the department will send them some kind of a notification saying, you were in the wrong loan type for public service loan forgiveness.
Thanks, Joe. John.
Yeah, I want to comment on Brian's remarks before the vote, and I'm sure it was not intended this way, but it sure sounded like a veiled threat, and I think that's not helpful. I'm just going to say that out there, telling us if you vote no, we you know, we're not, you know, we can do what we like, and that means we might do less. It's just not. We know this. There's no other point. And I took that as an attempt to. I'm not sure that it was intended that way, but to sort of coerce us into voting for consensus, and I just think it's not helpful. That's not that, you know, that is not going to make me vote yes when I'm going to vote no, and I just you know, it felt coercive even if that was not the intent, and I apologize for going out on a limb and saying that, but that was how I felt when it was said.
Brian, I'm seeing your hand up.
Yeah, I just want to say that was not the intent, and I'm sorry if it was taken that way. And you know, I tried to my goal there was just in the past we have had questions as to whether we're bound by what's on the table when we take a vote, and I just wanted to make sure that the committee knew that we're not. I understand that many of you are experienced negotiators. There are some who aren't. So that was my intent. I apologize if I said it in such a way that it was perceived as a threat. That's not what I intended. So I apologize.
All right, and thank you to the committee for their deliberation on this. I'd now like to move us to IDR, and it's my understanding the department would like to respond to the committee's suggestions from earlier this week.
Thank you, Brady. Just get myself. So turning to IDR, just as a summary where we are with that, we've again, in our attempts to conform PSLF and IDR, we've included the deferments and forbearances toward monthly payments for IDR. including the hold harmless process as well for borrowers that have been wrongfully steered into forbearances. So those months of forbearance steering will count as monthly payments. We've included defaulted borrowers into IBR, and that $0 payments can count toward forgiveness. We've included that the clock will not reset for payments after borrower consolidates. They will be able to count those payments prior to consolidation. And also we've included an auto enrollment into IDR. But a critical feature of the plan that we propose is lowering monthly payments for borrowers. We believe the marginal assessment will target benefits for those who have the lowest incomes while providing benefits to those who earn more. So, I mean, I realize that these changes may not be as comprehensive as many of you would have liked, but we will take your suggestions going forward. We feel like these changes will be important to borrowers going forward as well. That being said, many of the red lines that you suggested were captured in previous proposals that we ultimately did not include in the proposed text, but we did consider them, and we appreciate the thoughtfulness that went into some of those proposals. One thing we did change, and it was an oversight in the proposed language, was that we had meant to include under section H on page 6 for interest subsidy language. We want to make sure that that language now includes subsidy on unsubsidized undergraduate direct loans in addition to subsidized direct loans. And that was a comment that you did put in the red line. But we had intended to provide that from the outset. We also made the change that Daniel pointed out to include AmeriCorps forbearance on page 8. So we're putting forward our proposed text with those two changes forward without the red lines for consensus check.
Okay, I'll open up to the committee for final comments for the department. Persis.
Well, before we get to final comments, because I have many final comments, but I have a clarifying question for Jennifer on the change to the interest subsidy. I appreciate that we're now counting subsidized loans, but want to clarify that it is still just for $0 payments and not for anyone with any sort of payments. Is that correct?
That's correct, and we can look at the language right now, just so you can have a peek. Erin, if you can cue the IDR language on page 4. Right now, sorry. I'm sorry, page 6, paragraph H under interest subsidies. Under 4, H4, yeah, during all periods, with amount equal to the amount of accrued interest of the borrower's undergraduate direct subsidized and direct unsubsidized loans and undergraduate direct subsidized and direct unsubsidized consolidation loans.
Thank you for that clarification.
Mm-hmm.
Thank you, Persis. Anyone else? Any questions or comments? Yeah, Michaela.
So we're not even considering changing the name. Like none of the suggestions that we've put forward, not even just the name, but like in general, like there's been no substantive or even just surface changes or conversations. And so like I understand we're going to consensus, and usually you'll ask after, but that like I have to vote no. Like I appreciate that we're trying to lower payments, but I cannot support policy that just gives people a lifetime of debt. Like that is so overwhelming for me to have to consider. Not to mention that if I vote yes and say, okay, we lower payments because like that's something, right? That then it silences me in my ability to further advocate and say that I don't support the rest of the policy.
Jennifer, I see your hand.
Yeah, I mean, I think there were a lot of, great ideas. We just couldn't make those changes in this moment, and we'll certainly take a look at the suggestions further, contemplate them further. And we understand that this is not where the negotiators wanted the department to land, but we'll continue to consider your feedback as this process continues into the NPRM, including the name change suggestions.
Thanks, Jennifer. Jay.
Thanks. So I have a few remaining questions that I'd like to outline, more from, I guess maybe it's a little more practical. I just want to say, dating back to 2009, we've been tracking and counting qualifying payments on FFEL loans toward forgiveness. So we get that, we support it, but we don't fully understand the statutory authority that Brian referenced under 493C B7, how it's expected to work practically as we account for our loans and qualifying payments on the underlying FFEL loans. So, so the first thing is under the 685-209 K4-5. This is the provision where we count the underlying FFEL. Do we continue to count our payments as we do in FFEL regs? And that would be section 682-215F. And if that's so, I'd like to add the F to that reference in the regulation. That's my first question. The second one is, I'd like to illustrate with an example, sort of how Ed views FFEL borrowers with mixed, let's go with the undergrad and grad loans. How borrowers with mixed repayment timelines, like how is that supposed to work? So, and I think this also speaks to giving the plan to undergrads and not grads. So if you have an undergrad loan that has 10 years of repayment forgiveness credit, and then they've subsequently taken out graduate loans that have only 5 years of qualifying payment credit, when you combine those loans through consolidation into DL, how much does that new consolidation loan get? We've on FFEL, we have counters on loans. Okay. So I guess those are the two questions, and I'll get back in line.
Any immediate response from the department? Otherwise, we can come back to those. Not seeing anything, Jay. We'll come back to those, but Marjorie, please.
Thank you again. I think for all of the work that the department has tried to do on this, I just need to come back again to this issue of graduate borrowers. It's really problematic for a number of reasons. One, some graduate borrowers are also undergraduate borrowers, so we're actually adding complexity and increasing the likelihood for confusion in making these distinctions between when you got your education and for what. I think, again, we need to treat borrowers fairly. Some graduate borrowers have no undergraduate degrees, undergraduate loans for a myriad of reasons. And so these individuals are now being penalized and punished in a way that doesn't make sense. And I think the department hasn't actually answered why we're creating these distinctions between borrowers. And then finally, where we started again, this doesn't address issues of equity in education or educational outcomes. There's been numerous evidence and research presented that speaks to why many borrowers have to get additional education and additional degrees, beyond the fact that they're simply professions you cannot enter without those additional degrees, which connects to PSLF, as Persis has pointed out. And I think we're further disadvantaging students who are already marginalized, including students of color, women, and the same low-income students that we say we're trying to help. So I just want to go on the record saying that again, making it really clear that that language is problematic and doesn't do, I think, what the department said, right, that the aim was to make this simpler, to make this a plan that all borrowers are going to go into. And so I have to go on the record and say that again.
Thank you, Marjorie. Persis, please.
Thank you. I want to just start with this idea that Michaela started with, and our disappointment in the department's reluctance to accept really meaningfully any of the suggestions that we have made. It is very hard to accept the department's assertion that it is negotiating good faith here. You know, we have given you substantial feedback and received basically nothing. You know, where is the data that we requested on numerous pieces about who is in these plans, how, you know, how are their payments being applied? What are the constraints that the department and that this administration is under when it's making these determinations that it just can't do this right now? What is the basis for that? We don't, you know, we have not been given the information through this negotiation to really make meaningful choices, to provide, you know, feedback. This is the first time we've seen language, and it was, you know, take it or leave it. This does not seem like it was truly a negotiation in good faith. And I think that that is very disappointing. And it kind of belies the purpose of this entire process. That if you were to give us what are your constraints, we could tell you what is the higher priority, but it has been take it or leave it this entire time. We haven't even gotten the data. I requested for an update of the 32 borrowers number. How many borrowers have ever received cancellation under income during payment? We don't yet know that number. We know it from about a year ago, it was 32. It's abysmal. We've seen with the public service loan forgiveness, the department and the administration has taken strides to right a lot of the wrongs through the PSLF waiver. There are a number of folks who were left out of that waiver, and the PSLF regs have attempted to remedy some of that, although much of it is still lacking, but we have not seen the same kind of attention on income during payment, on low income borrowers who income during payment has not been serving. So what are the constraints that the department has been working under that has made all of our recommendations that we have been providing? We have provided pages upon pages of recommendations. And aside from just hearing that the department and the administration is not prepared to do this right now, we have not been given the feedback that we've needed to provide you with meaningful recommendations moving forward. I will reserve the rest of my comments so after Justin goes.
Thank you, Persis. Justin, please.
Yeah, thanks so much. I just really wanted to convey our extreme disappointment in this proposal. I think it's worth noting, and the department appears to have done so, what really seems to be overwhelming opposition to this IDR proposal. And while I voted in favor of the PSLF language, because I think it addresses some of, or perhaps even the majority of, the most substantial obstacles to borrower forgiveness under that program for my constituency, I think there are very real issues that exist within that program still. And I think the department's unwillingness to put forward an agreeable solution on IDR has exacerbated any of those remaining deficiencies and really colored the conversation around that topic and perhaps even the vote we took earlier today. So in our view, the department has seriously failed to meet the moment here to build a plan that addresses what I think and others I would imagine would agree with are the well-documented qualitative and quantitative evidence that shows that the current IDR plans, and I think Persis just hit this, that really shows the current IDR plans are insufficient, and which suggests that this plan will probably be unable to rectify in terms of insufficiencies. So I just wanted to make our position on this issue abundantly clear, particularly in connection with the PSLF issue. So thank you.
Thank you, Justin. Persis.
Thank you. And what I'd like to do is I'd like to go back to the stated questions the department has asked us through the process, to go back to what we've been told the priorities of this process would be. And this is to really reiterate the point that Marjorie was making earlier. But in the first issue paper, we have solution number 6. Data shows that underserved populations and communities of color face higher rates of student loan struggles than others. With design factors and changes can be better support equitable access and success in repayment. So we care about racial justice here. I care about racial justice. I believe that this administration cares about racial justice, yet this proposal is not responsive to the reality that faces borrowers of color. Borrowers of color are disproportionately going to take on Parent Plus loans and be graduate students. And I wanted to just point out like what a disparity this really is. Like looking at, I want to point us back to the article in MarketWatch from last month that discussed the experiences of Black women with student loan debt versus white undergraduate men, right? And the data that shows that a white man with an undergraduate degree on average earns $7 an hour more than a Black woman with a graduate degree. And so mathing that out, like let's look at what that means for what they will pay under these plans, right? So a Black woman in a family of 4 making $50,000 a year is going to have have to pay monthly over $100. The white man with an undergraduate degree making $50,000 with a family of 4 will pay 0. How is that equity? It is not equity. It is not fair. It is a failure of a racial justice analysis to exclude graduate borrowers and Parent Plus borrowers. Parent Plus borrowers right now have to do ICR, and unfortunately I wasn't able to get my calculator up faster, but that is an even higher than $109 a month. So we're really just on the dollar amount by income, there is a racial disparity here, and that is unfair, and we need to address it. Turning next to, on the first page of the issue paper, although IDR plans reduce monthly payments, borrowers who pay less than the rate of accumulating interest see their balances grow, sometimes significantly. We've heard a number of public comments talk about that. We have expressed a lot of serious concern about the impact of growing loan balances and what that does for borrowers' success longevity-wise. Here, you've done something for $0 borrowers, and I appreciate that, but it really fails to help a lot of low-income, moderate-income borrowers, right? And it creates just this financial cliff, and financial cliffs, as we all know, are just bad public policy. We need to have. Thank you. I'll return.
Thank you, Francis. Joe, please.
Yeah, I previously expressed most of my concerns here, so I'm not going to belabor the point. I'm adding +1s where I hear or I'm supporting other people's comments. I'm just going to put a big picture framing out here. I think EICR should have been a clear best choice plan for everybody in order to alleviate the alphabet soup of IDR plans that creates confusion and keep people out of the programs, to be honest. So I think that EICR is very far from a best choice plan, and it's only going to add to the confusion surrounding IDR. I don't think that this is the overhaul that IDR needs. And, I urge the department to seriously consider the items that we provided in the line by line, because I think instituting those could get this to where it needs to be. Thank you.
David, please.
Yeah, thank you. I think we're really at a crossroads here. I've paid attention to negotiated rulemakings for a number of years now and participated in past ones. I don't know that I've seen a moment where a committee and the department are so far apart, and that the committee is in such large agreement regarding a clear direction that they think a policy, regulatory language should go. And I find that somewhat concerning. We have a collection of experts here who have offered line by line edits. I think Persis has become the unofficial spokesperson of our concerns, and I think did a really excellent job laying them out. And I feel like more explanation is needed from the department regarding why they're unable to consider these specific points. I don't know what's holding them back, and I think the committee deserves a bigger explanation if, and in particular, if these proposed line edits aren't going to show up in what the final published regs are going to be. You know, we're speaking for very large constituencies who are all have vested interests in this program, and I think we need to just better understand the gap between the committee and the department.
Jennifer, does the department want time to respond to that?
I will just say that what I'm hearing is that we've made substantial improvements to the PSLF program, and there's still thumbs down on that. This is a negotiation. We've been here in good faith. As I mentioned before, we had priorities with IDR. We faced some real legal challenges, some hurdles that we just simply couldn't rectify in time for this session. That being said, there's some real gains here in terms of, I realize it's not comprehensive enough for this committee, but just to completely write off all the conforming changes that we made between IDR to PSLF to ensure that those changes are similar, to include the deferments and the forbearance, to provide a pathway for defaulted borrowers. Those are big wins. And I understand it didn't go far enough for you all. And we are going to continue considering this. This was a very ambitious agenda. I think we all have the same interests at heart here in terms of borrowers, and particularly low income, high needy borrowers. I understand all the comments that were made here. We'll take them into consideration going forward in the NPRM. But I disagree with the fact that to say that we have not done anything is, I don't think that's a fair assessment. And you've acknowledged that we've done so in PSLF, and we still gotten thumbs down on that. We've been here in good faith from day one. And that's all I can really say in terms of the IDR plan. But we have from the time that we've received feedback from you all, we have incorporated those suggestions. Not all of them into the text, but we have taken them very seriously, and we'll consider them going forward as well. So appreciate the feedback.
So conscious of the time, I am inclined to, I would like to take a check on this and then return to this if there is time, understanding that folks who are thumbs down will have the time and space to explain why they are dissenting to the department and to the greater committee and those who are watching on the live stream. But I do see hands up. Justin and Persis, is that check amenable to the committee, understanding that you will be given time for a dissent?
I mean, I guess you listen to us now or you listen to us later, so.
Fair enough. So with that in mind, I would ask for a show of thumbs for a consensus check on the IDR issue, and I will announce the thumbs as I see them. Okay, Justin, thumbs down. Marjorie, thumbs down. Bobby, thumbs down. Heather, thumbs down. Daniel, thumbs down. Joe, thumbs down. Jay, thumbs down. David, thumbs down. Jerry, thumbs down. Carol, sideways thumb. Persis, thumbs down. Misty, thumbs down. Noelia, sideways thumb. Michaela, thumbs down. John, thumbs down. Jennifer, thumbs up. What I would like to suggest now, knowing that we are not in consensus. Oh, David, I see your hand. Yep.
Did you record, excuse me, did you record Misty's vote correctly? I thought it was a sideways thumb, and I think you said it was down. Misty,
Oh, was it? Oh, I apologize. Misty was a sideways thumb.
Yeah, I was going to throw that in the chat. Thanks, David.
Oh, I apologize. But with that in mind, I would like to give people their opportunity to step away from the computer, and we will resume at 1 with explanations from the holdouts, and then move on to borrower defense. But thank you for your work in this morning's session.